Welcome to the second lecture covering Chapter 5, which is the chapter in which we're going to discuss pleadings. So when we were last together, we covered the first several slides. Let me advance to where we were when we were last together. We had gotten up to slide 20. Thank you. There we go. Sorry about that. So let's go ahead and get the lecture started. We're going to discuss class actions. The important rule for class actions is Rule 23. For this course, I require that you only know one rule number, which is Rule 11, Federal Rule of Civil Procedure, Rule 11. The reason that you need to know that is it's just such a common part of the lingo. It's shorthand. People all the time talk about Rule 11, and if you don't know what it is, you're going to miss out on some important flows of the conversation. After Rule 11, though, probably the second most common rule to know about is Rule 23, which is the class action rule. You don't need to know that number, but if you happen to have a practice that involves class actions, you will quickly become familiar with that number. Okay, so let's just pause here and pull up the rules so we can also have that as a reference point. I hope that you'll get in the habit in this course of using your federal rules of civil procedure very, very commonly. This is not the type of course where you're going to commit a lot of detailed rules to memory. You're going to refer to the rules. That's an important part of this process. Really, in this course, we're doing several different things. We're learning how the federal courts work, of course, but we're also learning how to interpret procedural rules. And the Federal Rules of Civil Procedure is a really smart way of starting that process because they are very easy to understand. They are the simplest rules that you'll ever have the privilege of working with. And so it's a good kind of first step or introduction to this topic. And so if you can get in the practice of, instead of relying upon, hey, Groover said this, or the textbook said this, instead dive into the rules and see if you can find what I found. And if you can't, come see me or raise the question in class so that we can get through it and make sure that you're comfortable with the material. There are very few subtleties or very few points along the line that you're going to get to and think, wow, I can't make heads or tails of this. It's not the way the rules are. Having said that, though, just like any other skill, it's something that you're going to become better at as you have more and more experience. So as we look at Rule 23, we can see Section A is going to be an important one for us. We're going to talk about the 4 requirements that's necessary in order to have a class action. Let me flip back, though, to our PowerPoint for now so we can talk about that. First of all, I think we need to know, well, what is a class action? And we have a definition right here. It's a good idea where you see content in red to realize that's going to be important, and probably what follows is going to be definitional. And in this case, it is. What is a class action? When we say class, we're not talking about school. We're talking about a group, a large group. And in fact, a class at Collin would probably or very possibly not be large enough to qualify as a class action, because you need to have a pretty significant number of people in order for something to be sufficiently large for a class action. So again, it has nothing to do with education. It has nothing to do with school. It has to do with the size of the group of people. So you might consider the use of the word class, like we might say that class of automobile, or that class of amphibian, or something along those lines, that category of individuals. Okay, so when we say class action, again, of course, the word action is referring to lawsuit. It's a civil action in which one or more parties who share a claim with a large group, so this is the class part, large group, of other identifiable persons sue in their own names and also on behalf of the other persons. Now, if you're like me, when you hear this, you're like, persons? Why are they saying persons? Why don't they say people? After all, isn't the plural of person people? Yes and no. In everyday conversation, you're absolutely right. When we're talking about more than one person, we say people. But person in the law means something different. Person in the law does include people whom we would call as persons in everyday conversation. Human beings is another term for that. But it also includes legal persons that aren't human beings. Corporations, partnerships, various associations, businesses. Those entities are persons under the law, but they can't become plural and become people under the law. They remain persons under the law. So the plural of a group of human beings would be people, but the plural of a group of if you had more than one legal person, you would have persons. So be on the lookout for that as you're talking about these concepts. Okay, so whether the class action is a class of plaintiffs or a class, well, okay, we're going to talk about it being a class of plaintiffs here. Excuse me, I'm jumping ahead of myself here. We're going to refer to that as the class. Okay, so why do we have class actions? Who does this process benefit? Well, let's pause for a second and consider a scenario. Imagine that I am prescribed a medication by my doctor. And as a result of the medication, of me consuming the medication, I develop a bad rash. As a result of the rash, I need to stay home from work for 2 days, and I have to take a prescription pill that costs $50. I will say I earn $20 an hour, so I lose 2 days of work, 16 hours at $20. So we'll round that, we'll say, about $400 is how much money I lost, ballpark. And then the pill, that's $450. Then I had the additional doctor's visit, that's $25, so we're up to $475. And, just discomfort associated with the rash. It was somewhat painful, somewhat itchy, somewhat unattractive. We're going to put that at $125. So kind of my total out of pocket from this rash was $600. Do people usually sue about things that are $600? Usually not. It usually doesn't even occur to a person. They think, oh gosh, this is a hassle. But they don't think about suing under those circumstances. And keep in mind, if I were to sue a big corporation, they would have a law firm to represent themselves. And so I would probably need to hire an attorney as well. Well, how am I possibly going to hire an attorney to represent me in a $600 claim? I mean, the law firm's expenses would be well more than $600 very, very quickly. So I'm probably not going to pursue it. But let's imagine that my weird rash isn't a one-off situation. And in fact, it's very common for people who are prescribed this medication to develop this weird rash. And but this side effect was not revealed in the various symptoms or the various side effects that can happen. And in fact, thousands and thousands of people suffered this $600 expense. Well, now we're talking real money. Let's say that 1,000 people suffered it. So instead of it being $600, we now have $600,000 of damages. Now we're talking some money. This case may be worth pursuing in more detail. Each individual person's damages are small, but collectively the total damages are significant. Now you can imagine being able to hire an attorney that might be interested in the case. That's how class actions work. Typically the group is large, but the actual damages that each member of the group sustained is relatively small. And that's how it plays out. So class action lawsuits are considered a positive legal development for plaintiffs, and if it's positive for plaintiffs, probably, as you can imagine, it's going to be negative for defendants. So that's the idea behind class actions. Let's go and look at the conditions that we have here. And these are the same 4 conditions that I just showed you a second ago. So this is going to be 23A. Federal Civil Procedure 23A. Okay, so these are the 4 prerequisites we have to have. The class, in other words, the number, is so numerous, so we call this numerosity, that joinder of all members is impracticable. This usually is going to be more than 30. That's requirement number one. Let's consider that for a second. If you had 1,000 people, you had Mary and Barry and Larry and Harry and Carrie and Jerry, etc., etc., throughout all the names, think about joining all those people. Think about the jurisdictional elements, all of the paperwork and administrative hassles associated with doing that. Would be pretty burdensome and would actually probably render the lawsuit kind of impossible to manage, just ridiculously expensive to even start it. Now, with 1,000 people or 10,000 people, it becomes that way quickly. You know, at 30, I'm not sure that that would be enough. Now, if these were 30 people, say, that were all located in the same county and they all knew each other, I think the court would probably say, you know what, I don't think it's so impracticable for these folks to get together. But if these 30 people are spread across the United States, don't necessarily know each other, that might be a situation in which the court might be more willing to grant it. So the court's going to look at the totality of the circumstances. It begins to be a possibility probably around 30. So that's our first requirement in order for a class action to be permitted. The next is there has to be questions of law or fact that are common to the class. Let's go back to my example of the medication that gives me a skin rash. Let's say it gives me a skin rash, but it gave Bob the hiccups, and it gave Susan indigestion, and it killed Jerry, and Teresa, it caused her to laugh uncontrollably. Well, we all had an effect from the medication, but the effect was very different. And it's very possible that some of the people who were affected maybe had some underlying issues. For example, yeah, I got the bad rash, but I also had recently changed the soap that I was using to wash my clothes. And so that might be a contributing factor. Teresa, who laughed uncontrollably when she after she took the medication, had just won the lottery. She had just won $100 million. So you might think, somebody in that situation might sometimes laugh uncontrollably. Jerry, yeah, he died shortly after starting the medication, but he had had some very serious health conditions prior to that. He had had a stroke. He also had had a heart attack in the past, and he had type 2 diabetes. And so you can see how, as we drill down, each individual potential plaintiff is really very different facts. So it's not obvious under those circumstances that they have common questions of law or fact. Obviously, this is ultimately going to turn on for the judge to decide, and it's going to be a very fact-intensive evaluation. But the closer the facts are, in terms of the similarities between the plaintiffs and the similarities in what happened to the plaintiffs, the more likely it is that the court's going to be able to find that there is a class. Let's talk for a second about the Dukes case. This is probably the most important recent class action case. Mrs. Dukes was a plaintiff, and she wanted to have a class of over 1 million plaintiffs. Wow. She wanted to sue Walmart. She had worked at Walmart for some period in her life, and she was a woman. She still is a woman as far as I know. Anyway, she sued Walmart because she alleged sex discrimination. And she wanted to, in her class, permit, I think maybe even all of the women who had worked for Walmart in the United States, but I could be wrong about that. It may not have been that big. But anyway, a lot of folks. She wanted to include women who were denied promotions, who were fired, who were disciplined, who were I can't remember other things, but those are some general categories. She wanted this class action to include people in all the different states, in all the different types of Walmart facilities, from stores to corporate offices to warehouse environments. I think she also wanted to include Sam's warehouses as well. She wanted to include hourly and salaried workers, and she wanted to include them in the class no matter what their particular circumstances might be. As you can imagine, a business as large as Walmart uh, regularly takes personnel action for lots of reasons. So there were probably some women in this category who there was videotape clearly showing that they had stolen from Walmart, and then Walmart had dismissed them. Well, those women would be members of this class, even though it was very clear, given this videotape, that they were in fact having stolen. So it really wouldn't have been a very strong case. Then there were other women who might have a very strong case of sexual discrimination, where they were manifestly the most qualified, the most experienced employee, perhaps having the best uh, uh, job reviews, and yet they were not given a promotion that went to a male who was less qualified. And so there would be so many different factors, and because Walmart is a fairly decentralized company, store managers and department managers are making many of these choices. And obviously, in any organization as large as Walmart, you can imagine there would be some store managers who would be very supportive of women's rights, and other store managers who wouldn't be. And so there might well be some store managers who were discriminating, and there might be others who completely weren't discriminating. And so all these women would be members of the class, even though the facts would be quite different. Well, this went up to the U.S. Supreme Court, and the U.S. Supreme Court said, there's not enough facts in common. Basically, the facts that we have in common are these people are women, and they all worked for Walmart at some time. But beyond that, the circumstances were way too different. And one of the big factors was the decentralization of how these employment decisions were made. So this can be a stumbling block for whether you're going to have a class action or not. Let's go to the third requirement. Claims or defensives of representative parties are typical. This is the typicality requirement of claims or defenses of the class. So let's say that I am chosen to, again, we're going back to the scenario in which I had the rash and was out $600, and I am chosen to be one of the class representatives. Typically, you're going to have you can have just one, but usually you're going to have several class representatives to reflect the diversity in this pool of individuals. So for example, let's say that going back to my case where people got the rash, some people got a rash that went away with just one dose of the medication, and they only missed 1 to 3 days of work. Really no big deal. But some people developed a persistent rash that continued for at least 3 months, required multiple treatments, and was really disruptive of their lives. We'll call that category 2. In category 3, for some folks, the rash became so serious that it resulted in infections, and that people had very serious side effects as a result of this, and they had to be hospitalized. Some of them had disfiguring scars as a result of it. So those are the 3 levels that we've kind of divided this scenario up into. Well, I'm one of the lucky ones. I only had the 2-day rash, and so I would be typical of that first group, and so I would be a good representative of that group. But I wouldn't be a good representative of the other 2 groups. So you'd want to find class representatives, at least one who had the 3-month version of the rash. And then you'd want to have another representative, at least one, who had the infections and other complications from the rash. There might also be other differences. For example, what dose was I on? What other medication was I on? Those types of things might be relevant in sorting through the typicality issue. Let's look at the last requirement. Representative parties, again, this is me, one of the people that's going to be named in the lawsuit, will fairly and adequately protect the interests of the class. Let's say that I am selected to represent the group of folks who got the 2-day rash. And so as the case goes forward, I'm going to be kind of the face of that category. Well, the law firm promises me, because I'm going to be that face of the category, that I'm definitely going to get 100% of my damages, even if the other people in the class don't fare so well. Maybe they're only going to get 50 or 60% of their damages. But I'm going to get 100% of my damages paid first. I'm going to be at the front of the line. Well, guess what? That means I have a conflict with the other members of the class. I'm getting preferential treatment. And so under those circumstances, I would not be an appropriate representative party. I have to be treated the same way that members of everyone else who's in the class would be treated. And obviously the court is going to have to determine whether these 4 things are satisfied. Usually there's a hearing on class certification. That's what this is called, class certification, at the early stage of the lawsuit. And this is oftentimes the most important part of the lawsuit. It sounds funny to say because it's really just a procedural matter. But if the class certification is denied, well, that probably means that the case isn't going to go forward, because if there isn't a certification, the few plaintiffs that have been identified that are already part of the lawsuit, their damages aren't significant enough typically to motivate the attorney to go forward with the case. And so when the class certification is denied, oftentimes that means that the case isn't going to go anywhere. Or at least from the perspective of the defendant, it goes from being a big deal matter to not so big of a deal of a matter. On the other hand, if class certification goes forward, it's pretty common for, and the defendant doesn't think that there's a serious basis to appeal this at some later point in time, it may well be that the defendant decides, hey, you know what, we better go ahead and settle this case. It's going to be very expensive to defend a class action, and so why don't we just go ahead and cut our losses at this time. Let's just pause here and look at the rules. I went through the rules briefly from the perspective of the slide, but here we'll see the actual rules, and you can see really what is on the PowerPoint is just a quote, just a summary of the rules that are already actually part of the rules. You can see here the requirements are: the class is so numerous that joinder of all members is impracticable. There are questions of law or fact common to the class. The claims or defenses of the representative parties are typical of the claims and defenses of the class, and the representative parties are fairly and adequately can protect the interests of the class. Let me talk for a second about something I haven't pointed out yet here about the rules. I'm going to make the blue go away. When you read rules like this, and this isn't a long list, but in statutes and in rules, sometimes you'll have a list, not 4 items, but there might be 40 items. And so when you sit down to read it, you really don't read it from top to bottom. I mean, you might, but you're really going to focus on a particular part, at least after the initial read. And one thing that's important to notice, it's not so important when you have a list of 4, but when it's a list of 40 or 100 or something, is to go to the penultimate one. So this is the ultimate one, this is the last one, and then to go 1 up from that. So 4 minus 1 gets us to 3. And then to look at the end of the line, and typically there's going to be the word and or. I recommend that you go back and put whatever this word is here, print it here and print the word and in all the other spots. That way you won't forget that it's an and or an or situation. We all know what and or mean, but just a little refresher. And means that you have to have all 4 of these things. If you're missing even one, if you have 2, 3, and 4, but you're missing 1, guess what? You can't have a class action. Or let's say you have 1 and 3 and 4, but you don't have 2. Guess what? Can't have a class action, because and means you've got to have all 4. But if this were the word or, then that means you just have to have 1 of the 4. So if we have 2 but nothing else, and it were an or situation, we'd be good to go. Or we have number 4, but we don't have 1, 2, or 3. If we had an or here, we'd be good to go. So it's really important to know whether there's an and or an or in the penultimate position. And again, it's good, and particularly in a long document, to just go back and put the ands and ors in so you can keep that straight. Let's go back to our PowerPoint. Okay, so after approving the class, the court will direct all members of the class to get notice of the action. So now it's the duty of the plaintiff's counsel to go ahead and find these people. Many times they'll be able to get the names from the defendant. Of course, it's depending on the circumstances, but let's go back to the Dukes case. Well, obviously Walmart knows who it has employed, and so it would have a list of all of the employees that it has, and obviously a lot of those would be women. So that would most likely be the way that the plaintiffs would find the people that it would need to contact to let them know about the class. Each one of those individuals is going to have to get an individual notice. Typically, it's going to be mailed to them. You've probably gotten some in the mail. You may, depending upon your age, you or your parents might have gotten a Blockbuster notification when Blockbuster existed and was subject to a few class actions. You may have also gotten them with respect to medications or other things. Anyway, there is usually an opportunity in those documents to opt out. Some class actions are opt-in and some class actions are opt-out. Most are opt-out situations. You have to look at the statute to know whether it's an opt-in or opt-out situation. If it's an opt-out situation, the default setting for that particular class member is that unless he or she does something, he or she will be a member of the class, and he or she won't be able to sue separately unless he opts out, unless he chooses to formally take an action saying, I don't want to be a part of this lawsuit, I want to advance my own lawsuit perhaps separately. If a person opts out, he isn't going to get any goodies from the lawsuit, but he's also not limited by whatever happens in that lawsuit. It's common for paralegals, by the way, to prepare this notice, to develop the lists and the address and all the database to make this happen, and to send out those types of communications, and then to manage the opt-out data. There's practices where that's really the primary function of a paralegal, and so that's can be this type of job would be particularly meaningful for a paralegal who's very, very well organized and who can make sure that everything is running smoothly. It's a more of a managerial job probably than a legal job, although you certainly have to know something about the law too. Okay, now we're going to go back and talk about the complaint. We're talking about the purposes of the complaint. Let me, before we do that, let me just go and look at an example of a complaint. So I'm going to end this for a second. I have a complaint here. It's a pretty good one, so we're just going to use this one for a second. This is a local one. This is a real complaint. You can see that this is filed. I'm going to flag this one. Here is our court in the U.S. District Court for the Eastern District of Texas, Sherman Division. So this is our court. We can see it has the section symbols here. You can see they're nicely lined up, nicely spaced, so this is a well-presented document. You can see that we have one plaintiff, comma here, indention, plaintiff, comma here, lowercase v, period. Then we have one, oops, sorry about that, one a defendant, comma, indention here, defendant with a period. Then we have the civil action number. It does not say that a jury, it does not have the word jury. I think it probably does have a jury demand at the bottom. But nowadays you would see the word jury here typically. And then we have the name of the particular complaint. Again, it follows that same pattern. We start by identifying the party. In this case, it's Mr. Jackson, or since just one plaintiff, they don't have to say Alvin Jackson, they can just say plaintiffs. And then we know this is the first one, so it's original. And then we have the actual name of the document, the pleading, in this case, the complaint. As we look at the bottom, you can see in the footer of the document, we have plaintiff's original complaint, and we have the page number. It's very common to identify sections by Roman numerals centered. So Roman numeral 1, Roman numeral 2, we'll go see Roman numeral 3, 4, 5, 6, 7, 8, 9, 10. Oh, there is a jury demand here. 11, I guess that's the last one. Unless the local rules require it, you don't have to do it, but this is very, very common. Another thing you'll see is that you'll see the Roman numeral above the actual title. So this would be, Roman numeral 1, introduction, Roman numeral 2, parties. You might think this looks a little odd, and I suppose it does, because you'd ordinarily think that you would put this, oops, on the same line as this. But for whatever reason, that's not commonly done. Then we have a little introduction here, and this little bit of a paragraph, in this case, isn't numbered. We're going to call this the preamble, but all the other paragraphs are. So we can see it's indented, one indentation, then it's indented one more. You could have the whole paragraph indented, depending upon the local rules. That might be a practice. It's commonly done. In this case, it isn't. This is the more common one that I've seen, but I've seen it the other way as well. And so each paragraph is numbered 1, 2, 3. And as we go through here, you'll see, let's go all the way to the end, we have a total of 55 paragraphs. And you can see, let's say there's a dispute about paragraph 48. If we had numbered them, it would be kind of a hassle for us to count it up. And you could see how you could easily get off count. There might be a paragraph up here that's unclear whether, well, did that start a new paragraph, or was that a continuation of the old paragraph? I don't know if there's any examples of that, but sometimes it's not always obvious whether it's a new paragraph or not. And so the fact that we've numbered it removes all doubt about that particular paragraph. Okay, so let's go back to our preamble. It's not usually a requirement that you have a preamble. This is a pretty common structure for it. This is a little bit, I don't say it's old-fashioned, but it's a fairly common way of phrasing it. You're addressing the court, and you're saying the plaintiff, in this case Buford T. Justice, files his original petition against defendant Burt D. Bandit and alleges as follows. That's a very common way of saying it. You can see it's written in a plain English style. It's not overly lawyered up in terms of language. Another way that this used to be stated that's more lawyered up would be I won't write it up. Comes now plaintiff and files this original petition against defendant, and would show as follows, and would respectfully show as follows. Again, that's not wrong, and lots of attorneys would say that. Many times the comes now would be incomplete, it would be in all caps. It would be an example of how you might want might be said, and there's nothing wrong with that, but probably better to stick to just plain English. Let's look at that preamble paragraph in the Jackson matter. Plaintiff Alvin Jackson files his original complaint against defendant Frisco Independent School District. So definitely plain English is in application here, and you can see they did not number this paragraph, so that's good. Now you may wonder here, what is this item in a parentheses? Well, what the plaintiff is doing in this case is defining the term. Going forward, whenever you see in this complaint, this word complaint with a capital C, it's referring to this original complaint. We've defined this term to be a synonym with this term. Many times you'll actually see the parties, here, let's see, I'm going to do annotation here. The person will put this in quotation marks. That's probably more common to be done, but it's obvious in this context what is meant, that the equivalent of the quotation marks are being used. So I would probably use the quotation marks. I think that makes it even slightly more obvious, but it's not wrong not to. We'll see down here as we get to this next paragraph is that we have another definition. We have defendant Frisco Independent School District, which they've defined as FISD. Now let's say that in this lawsuit at some point they talk about the Forney Independent School District. Well, it's probably referred to commonly as FISD in Forney, Texas, right? Makes sense. But Even if they repeatedly refer to Forney ISD, they're not going to refer to it as FISD because this has been defined to mean this and only this. It can't mean anything else. It can't apply to the to the Forney School District or the, Freeville School District or anything else that might look like it. And so there's lots of ways you can define it. A pretty common way to define would be to define it as defendant, or you could have done Frisco ISD. You typically want to pick something that's pretty intuitive because you want to make the reader to easily identify what you're talking about. So you wouldn't want to name, the defendant Frisco Independent School District. You wouldn't want to name it Bob. I mean, that wouldn't make any sense. You want to pick one that's a sensible name that the person doesn't have to work hard to keep track of. Let's go to the next slide. Oops, I guess I need to get rid of those. Well, here we go. Sorry about that. Clear. Awesome. Okay. Here's the example of the older form. This, again, is very common. You'll still see it today, but it is definitely on the way out. To the Honorable Judge of said court. Let's just look at this for a second. Here we go. Let me annotate here and give you some comments about this. Said court. When we see the word said, what we usually think of is the past tense of the word to say, right? He said he would be late, meaning he did say he would be late. But in this context, what we're doing is we're referring to a court that we've previously mentioned, and we're calling it said court. It's not incorrect grammar, but it is not good plain English, and so we don't want to say that. Let me flip back for a second to the previous slide. And you can see they just say the court here as opposed to said court. Let's go on. Comes now, so you can see that old-fashioned term. It's not a big deal to use if your attorney with whom you work likes it, just for tradition. There's nothing wrong with it. Comes now, Buford T. Justice, the plaintiff in the above referenced and styled case. And again, this is just saying the plaintiff in this cause, actually it's not case, it's cause, and makes and files this, his original complaint against the defendant, Burt D. Bandit, and for such would respectfully show this honorable court and jury as follows. This is just a long way, so you can see we have a total of 3 lines here compared to a little bit more than 1 line. And we're not really adding anything of substance. So probably a better practice would be to use the plain English. This is one of the areas, though, that I wouldn't have a heart attack if your attorney wants to keep the more old-fashioned language. Going beyond the preamble, though, that's when you want to start saying, well, maybe we ought to make this a little bit more modern. Okay, next we're going to have a section typically called parties, and this you're going to identify the party by the type of party he is. Is he a party guy? No, I'm teasing. He's not a party guy. Well, is he the plaintiff? Is he the defendant? Is he the counter defendant, counter plaintiff, or whatever? You'll want to use the full name of this person. Obviously, if it's a human being, that's usually not too hard to know, but if it's an entity such as a partnership or a corporation, you're going to need to research that. You're going to have to go to the Secretary of State records and pull up that information to get it right. And of course, you're going to want the name to perfectly match the caption. And obviously, if it's a case where the person is not the real party in interest, but just the representative, then you'll want to explain that representative status. So here's some examples of, go back and here are some examples of how you might to define the parties. And you can see here we have the same structure, Roman numeral, then on the next line, parties. Oftentimes this will be in bold. Could be underlined, doesn't have to be underlined. And you can see paragraph 1, Plaintiff Buford T. Justice, and notice that obviously you're going to want to put these in commas. I mean, you don't have to with respect to, go ahead and annotate here, with respect to this, because you could omit this comma and omit this comma and just say Plaintiff Buford T. Justice is an individual who is a citizen of the state of Texas. But the problem is that oftentimes people will have Plaintiff Buford T. Justice. Well, okay, it's not terrible. But they will keep this comma but omit this comma. And it's better to have both commas for clarity's sake. So you want to go ahead and either don't have any commas or keep both commas. Because really this is a parenthetical statement. We already know who the plaintiff is. The plaintiff is an individual citizen of the state of Texas. And by the way, what's his name? Oh yeah, this is a little additional nugget of knowledge. And we have additional nuggets of knowledge. We put those parenthetical type statements within commas. The same thing is here with our defendant, comma, Bert D. Bandit, comma, an individual and citizen of the state of Georgia. And again, this is another parenthetical about Bandit, so we're going to have to keep it within comma. So this comma is actually a dual purpose. It's the brackets around this one, and it's the brackets around this one. May be served with process at this location. Okay, so let me go ahead and clear this. Let's go back and look at our other, the Jackson lawsuit here. Here we have our parties. Plaintiff Alvin Jackson, you can see here they have chosen not to put these within commas. They could have, it wouldn't have been wrong, but it's fine not to. But again, if you're going to put one comma here, you ought to put them both. If you put one comma here, you ought to put them both. But you don't have to use any of those commas if you don't want to. Defendant Frisco ISD, FISD, is a school district organized under the laws of the state of Texas. FISD may be served with citation, including a copy of this complaint, by serving the FISD Superintendent of Schools, Rick Reedy, at this address or wherever he may be found. So that's a good this party section. Let's look at some additional information about the party descriptions. Now we're going to be considering the defendant. So we're going to want to describe the type of entity the defendant is. Obviously, if it's a human being, we can just specify that it's a person. But it could be a partnership or a corporation. Of course, also the plaintiff might be that. Then you'll want to describe where the person can receive service. If it's a corporation or an LLC, they will have to have specified somebody who can be the agent for receiving the service of the lawsuit. And so that will have to be stated. You'll have to look up that person in the Secretary of State website to find that out. So here's an example. Defendant, Paradise Found, Incorporated, and you can see the commas are around it, is a corporation that is incorporated under the laws of the state of Idaho and has its principal place of business in the state of Idaho. Defendant may be served with process by serving as registered agent Sam Paradise, so this is the equivalent of Rick Reedy, at this particular address. Now going back to the Rick Reedy thing, he's no longer the superintendent of Frisco ISD, but at the time he was. The fact that he's being served doesn't mean that Mr. Jackson is making any allegations, that he even knows who Mr. Jackson is, or that he had any involvement with anything that went awry in Mr. Jackson's employment. This is just the person that's been designated by the organization to receive this document. He's a responsible person. Sometimes it's the head. Sometimes it's going to be something called CT Corporation. Sometimes it's going to be the general counsel. It could be somebody quite a bit far down the organization. But again, you're going to be able to find that through the Secretary of State. If we're talking about a human person, we're obviously going to actually have the person's contact information included. Okay, so now we're ready for the next section. This is the first section. Remember, we said the 5 things that you have to have in a complaint. Well, we've already talked about the caption. That was number 1. Now we're up to the second item, which is the subject matter jurisdiction. You may recall in Chapter 4, we talked at great length about subject matter jurisdiction, and so this should be hopefully rather familiar to you. Let's look at how this works in the context of a federal court complaint. Again, typically we're going to have this section be called jurisdiction. Oftentimes it's going to be, sometimes it's combined with venue, so you can have jurisdiction and venue, and then it's going to have that Roman numeral. And you're going to make a short explanation about the grounds for jurisdiction under these circumstances. In this particular case, we have a federal question for this example here. And you can see that there's a federal statute. This is a federal statute. And that's why this particular claim gets to be filed in federal court. So this isn't a diversity situation. That's also the case, I'll just call it a federal statute. That's also the case with the Jackson case. We'll see that in just a second. So in this particular case, the court has jurisdiction over the lawsuit because the suit arises under the Equal Pay Act of 1963 as amended, and here's where you'd find it in the U.S. Code. Defendant violated the act by engaging in sex-based wage discrimination between men and women in the same establishment who perform jobs that require substantially equal skill, effort, and responsibility under the same working conditions. You don't know this because you're not that familiar with the statute, but this is almost a verbatim quote from that statute. It's very common. This sentence is not strictly speaking necessary, but it's very common to put it in here to show that your facts are lining up with the allegations or the necessary allegations in the statute. Okay, so we're going to actually cite the particular federal statute in this case that is relevant, and you're going to cite specific facts supporting it. Again, that's a best practice. Let's look at the Jackson case to see how that works. Jurisdiction, again, Roman numeral 3. This court has jurisdiction over this action pursuant to this particular statute because Mr. Jackson asserts claims arising under federal law. Now you may see in this case that Mr. Jackson hasn't even said which federal law is at issue, nor has he alleged any facts in this section. So this particular complaint isn't as robust as this one. Basically, this part is missing from the Jackson complaint. But it's very common for it just to mention, I mean, this is, I'm sorry, here we go. This is very boilerplate and not at all unusual. Here's an example of diversity jurisdiction. This is another, obviously, very common way to get into federal court. In fact, the single most common way to get into federal court. The court has jurisdiction over this lawsuit because of this section. And by the way, let's just go ahead and look. Copy. Why don't we just look at this statute so we can, I'm just going to put it into Google. Again, we've gone to the Cornell website. And this is, again, diversity of citizenship, and we can see the way that you get diversity. Again, this is the stuff that we talked about in class about complete diversity. And then we see here the $75,000. Let's look at the federal question jurisdiction, which is this one, federal question. And here, The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. So this is the basis for Mr. Jackson's lawsuit being in federal court. So let's go back here. So the court has jurisdiction over the lawsuit because of, again, this is the diversity statute, because Justice and Bennett are citizens of different U.S. states, and the amount in controversy exceeds $75,000, excluding interest and costs. Specifically, Justice is a citizen of the state of Texas, and Bennett is a citizen of the state of Georgia. Justice is suing Bennett for personal injuries in the amount exceeding $75,000, excluding interest and costs. Now, in this example, we have citizen in red, but you wouldn't use red when you are actually filing your lawsuit. You would, oops, sorry, here we go. You would not want to do that. You would just use normal things, normal font. So I included the red just so you could easily see the citizenship aspects, but when you're actually filing it, you won't do anything funky with that. Other than underlining and italicizing things according to Blue Book rules, you're really not going to add any flair to your papers you file in court. We're going to talk a little bit about interim and quasi-interim here. Obviously, that's not a major focus of this class, but just in the interest of being complete, we're going to touch on this briefly. Pleading the grounds for personal jurisdiction, interim jurisdiction, or quasi-interim jurisdiction is optional. You don't have to list that basis. As you can see in Mr. Jackson's lawsuit, he doesn't say why the court has personal jurisdiction over Frisco ISD. It's pretty obvious, but it's not absolutely necessary that you do so. If you think it's a matter that's going to be in contention, though, you certainly can add those facts. Keep in mind that the defendant is going to end up waiving personal jurisdiction objections if he doesn't file a special appearance before he answers. It's also optional to list the grounds for venue. You don't have to do that. In this example, this particular party chose to combine venue and jurisdiction, which is common. In the Jackson matter, we'll see in a second that venue is separate. You don't have to do it, but it's very common to do so. It says venue is proper in this district under this particular statute, which we'll pull up in a second. You can see it. Actually, let me go ahead and, because a substantial part of the events or omissions giving rise to the claim occurred in this district. So let's go ahead and type that in here. And this is the basis for venue. And this is really what we're looking for. Remember the three ways you can have venue. A civil action may be brought in a judicial district where any defendant lives if all defendants are resident of the states in which the district is located. Or, and again we see or here, so we can add an or right up here. Or a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of property that is subject to the action is situated, or there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to this action. So here are three ways of getting venue. And they are saying that it's that second basis, a substantial part of the events or omissions giving rise to the claim occurred in this district. So they are saying it's number 2. And you can see they basically just cited the statute. People don't get creative here. There's no need to reinvent the wheel. People just cut and paste from the statute. It's easier and it puts you at less risk because if you're actually using language in the statute, you can't possibly get it wrong. Let's look at the Jackson lawsuit here to see the venue facts. Venue is proper in this court pursuant to, and you can see it's the same statute, because Frisco ISD resides in Collin County. So Frisco ISD is the defendant. It resides in Collin County. and pursuant, so they're saying there's two bases pursuant to that same statute because a substantial part of the events or omissions giving rise to the claim occurred in Collin County. Let's go back and look at this statute. So they're saying both of these are satisfied. We only need one of them being satisfied, but in this case we have both, so we're even more secure than we otherwise would be. Just make sure here we don't have anything else. Okay, so now we're done with venue. So we had section 4 with venue. Now we're ready for the story to begin. Up until this point, it's kind of a boring document, no offense, but it's really hard to get too interested in the ins and outs of the plaintiff and the defendant and jurisdiction and all this kind of stuff. Now we're getting to where the jury might be interested in some of this stuff. The judge might be interested in some of this stuff. We're about to tell the story of this particular lawsuit. Okay, so what are we looking for here? The complaint must contain a short, plain statement of the causes of action entitling the plaintiff to relief. So we're typically going to be looking for two things here. We're going to be looking for facts, and we're going to be looking for legal theories. Another term for that would be causes of actions. It's not absolutely required that you list legal theories. It's a best practice, but it's not absolutely required. You can combine facts with legal theories, but more commonly people will talk about facts, they'll call cause of actions, and have those separate. Why do they do that? Well, lots of reasons. One thing is if you're telling a story and you're breaking it up, you're interrupting the story to make an extensive legal theory presentation, the story's going to end up getting kind of boring, to be honest with you. It's going to get kind of broken up. It's going to lose the flow. So you want your facts to be interesting, engaging, telling a story without kind of having a commercial break to talk about the facts. So that's probably the biggest reason that people separate the two. Let's look to see how this might be presented. Oh, okay, well, let's first of all talk about notice pleading. This is a really important concept. You can see it is in red, so it's a definition. Notice pleading is all you need to do in federal court, and it's actually all you need to do in Texas state court too, and it's true in most courts. It used to be the case once upon a time, a million years ago, or at least several decades ago, that we were not notice pleading. We required fairly technical things in our pleadings. And so what would happen is a person could have a perfectly good lawsuit, but if they didn't use the quote-unquote magic words, the quote-unquote magic terms, their lawsuit might be thrown out. And if they were near the statutory deadline, they might lose their claim entirely. But even if they weren't, they were going to incur unnecessary expense because they will have paid the filing fee, then they'll have to repay it, and then they'll have to serve the payments again, and it's just a burdensome process. And really, what was being gained by having all of these technical impediments to the plaintiff filing his lawsuit? The fact that the plaintiff wasn't successful the first time because he missed a technical requirement really had nothing to do with the strengths or weaknesses of his case. So as a result, the court system, both in the state and federal level, have moved to notice pleading, where you have to just plead enough so the defendant has enough information to know what he's being sued about. So it's fair. You don't have to go into elaborate, detailed facts. You don't have to use magical legal terms. You don't even have to allege every fact that's necessary for you to win your lawsuit. But, you know, just because you can get away with doing a very minimal amount doesn't mean you ought to try for the minimum. You don't really benefit from trying to do the absolute minimum. There can be strategic reasons why it's a good idea to go above and beyond. So obviously you want to talk about the time and place of whatever the incident is. And you want to avoid conclusory statements. You don't want to say something like, defendant violated plaintiff's rights to XYZ. You want to tell the story. What did he do that you say violated his rights? So you want to, for instead of saying defendant committed negligence, you want to say defendant ran the red light and switched lanes at the same time hitting plaintiff's car or something like that. You're telling a story. You are presenting the facts in such a way that it's obvious that there was negligence. So here's an example of how we might have the facts section. On this particular date, and again, you won't actually have this. You'd have all this be in black ink. But on May 29, 2016, by the way, notice the use of the traditional date mechanism. We don't want to put THs, whether it's superscript or not. We don't want to say the 29th of May. None of that works effectively in legal writing. We want to have month, day, comma, year, comma. That's, or period would also work in this structure. We never have, in this spot, we never have no punctuation here. We have to have something after the year when you have month, date, comma, and year. Now, if we were just referring to the month of May, so say that it was instead in May 2016, you wouldn't have a comma after May, and you aren't required to have a comma here. Now, grammatically, you would be, because this is a clause, an introductory clause that we need to end with a comma. But we don't have to, but it's preferred that we end with a comma here. But you aren't always required to have a comma in that situation. Anyway, let me go on to the next one. On May 29, 2016, at 3 p.m., Justice and Bandit were driving automobiles on West Houston Street in Sherman, Texas. This is fine. Probably more people would say on or about, but he does say around. So that's giving some approximation. You don't want to say at 3 p.m. as if you are 100% certain it wasn't 2:59 or 3:01 p.m. Bandit negligently drove his automobile across the center median at West Houston Street, striking Justice's vehicle. Pretty good description. We're using the word negligently, but we're also telling the story. So that's an effective way of describing the facts. There are some times where you have to plead certain matters with more particularity, and that's going to be Rule 9. These are circumstances involving fraud or mistake, or when you're alleging special damages, such as pain and suffering. Let's look at Rule 9 so we can see what's going on there. So let's look at Rule 8 for a second here, just for a second. We've already gone over the jurisdictional requirements, and now we're up to this section. We're giving a plain and short statement of the claim showing that the pleader is entitled to relief. Now we're going to go forward into Rule 9 and see when we're pleading special matters. When it's fraud or mistake being pled, in alleging fraud or mistake, a party must state with particularity, in other words, more detail, the circumstances constituting fraud or mistake. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally. Then we have conditions precedent. In pleading conditions precedent, it suffices to allege generally that all conditions precedents have occurred or have been performed. We'll see more about this later on, so kind of flag that in your mind as another issue that we're going to have. And again, we have special damages. If an item of special damages claim, it must be specifically stated. All facts alleged in the complaint have to be true. Okay, this is a little tricky. I mean, you're not going to be surprised by that. Obviously, you can't go around lying to the court. That's not a good thing. But sometimes you don't know. You as the plaintiff don't know everything that's going on. And we'll see this in a second with the Jackson matter. Imagine for a second that you were dismissed from your job and you feel it was because, we'll say it was your religion. That's what your gut tells you is the reason you were fired. It's unlikely that your employer actually said that to you. Hey, Bob, we're letting you go because you're a Presbyterian. You know what? People don't admit that, even if that's what they're thinking, because they know that's unlawful. So they're going to come up with something else. They're going to say, Bob, we're letting you go because business is slow. Or Bob, we're going to let you go because, you were tardy one time 3 years ago. They're going to come up with something. And so when you file your lawsuit and say, well, I was a subject to religious discrimination, you aren't going to know that for sure. It's what you think. And you're going to have some basis for thinking that, but you're not really going to know for sure. And so you are going to investigate the facts before you go forward. Certainly the attorney and the paralegal need to do that. But sometimes you're just not in a position to be able to conclusively say that. After all, you haven't had the opportunity for discovery. So at this point, the defendant has had no obligation to share information it has with you. So sometimes you're going to cite things based upon on information and belief. This is when you're saying, look, I think this is true, but you know what? I could be wrong. So using this term gives yourself a little extra wiggle room. On information and belief, and again, you're not going to actually put it in red. On information and belief, Bandit was using a cell phone at the time of the accident. You know what? Justice isn't sure about that. He thinks that was probably the case. He saw that the cell phone was open in the lap of Bandit, but he doesn't know for sure that he was using it. So this is a way to protect yourself from Rule 11, to be honest. If you put on information and belief, you're giving yourself a little bit of protection from Rule 11. That's not a magic potion. If you really didn't have a basis for thinking that was true and you said it in your complaint and you are maybe going to get sanctioned for it, the fact that you said it on the information and belief doesn't somehow protect you from any Rule 11 review. No, you can still get a review, but because you gave yourself some wiggle room, because you conceded you didn't really know, the court would be less likely to sanction you under those circumstances. Typically, you aren't going to keep on referring to people by their long names. It kind of breaks up the flow of the story. Sometimes names are very similar if you have a corporation and a subsidiary, and it can get very complicated. And so you're likely to have defined the names of folks. You may also call them by their last names, for example, or by the entity names. This I have here, I'm saying do not describe people by their status. This is not an uncommon thing to do, and if your attorney thinks that's preferred, and again, the local practice in certain areas or even local rules may require this. The problem is that it kind of breaks up and makes it hard to follow the story, because you have to remember, again, there may be multiple plaintiffs, multiple defendants. It can become a little bit confusing, and it may undermine your efforts to humanize your particular client. So keep that in mind. One thing you definitely don't want to do, though, is refer to the other side by its designation, plaintiff or defendant, and give your client a warm and fuzzy name. You don't want to be that kind of obvious about it. So if you're going to call the other side plaintiff, you better call yourself defendant. So here's some examples of abbreviations you might use. Again, you want them to be relatively short, but logically connected to the entity that you're talking about. Very common to add exhibits to the complaint, perhaps the copy of the contract if it's a breach of contract case. And you're going to refer to those exhibits in the body of your document. And an example of how you might phrase that right here is, a true and correct copy of this complaint is attached as Exhibit A and incorporated herein by reference. Now I'm going to flag a few things. I don't think you really need to say this. You definitely would not want to say herein. Now, you may say here, if you're like me, why are we using passive voice here? In a complaint, in a pleading, you really don't want to use first person. After all, the attorney is the one who's signing this document, and you could say, I have attached a true and correct copy of this contract, but that's really too informal for a pleading. The attorney doesn't want to insert himself or herself that much. So in this situation, I think it is perfectly fine to use passive voice. Again, you want to use it as minimally as possible, but this is one situation where it's okay. Obviously, you're not going to use the red font, and you don't want to use it in this paragraph. This paragraph, you want to be active voice, but this one is fine if you have passive voice. And again, you can do it with letters or numbers, it doesn't matter. You might define a particular exhibit. For example, you might put in parentheses, Trans Am contract. I guess I should put contract in there. Again, you're going to capitalize all the letters of the first letters of each one of the words. And you could have actually put this definition maybe right here, but that could be one way of approaching that. Okay, so now I'm going to flip over and we're going to look at the Jackson complaint. So we're ready for the facts section here. You can see that this facts section goes on for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 27 paragraphs. The whole document only has 55, so literally it's just one paragraph shy of being half of the document. Your bread and butter, your most important part, your longest part is going to be your facts section by far. And don't be surprised if your facts section is longer than all the other parts combined. So let's look at the facts here. Alvin Jackson is a teacher at Frisco High School in the FISD. Mr. Jackson is the only African American coach and core subject teacher at Frisco High School. These are effective paragraphs. I might change it up a little bit. Let me just give you some thoughts about how I might approach writing this. But it's well done. We might say teaches. So we have some nominalization there at Frisco ISD in the Frisco ISD. Mr. Jackson is the only African American coach and core subject teacher at Frisco High School. I think that that's a pretty effective paragraph. Each one of the sentences is long. If they're an active voice, they're communicating important information. It wouldn't have been unusual if we had already defined Mr. Jackson earlier, but we didn't. On April 18, 2011, again we have the month, the date, comma, year, comma, Kate Smith, Associate Principal at Frisco High School. So again, we have the comma because we're now defining, we're giving us a parenthetical about Mr. Smith. Well, let's learn some more stuff about him. Oh yeah, he's the Associate Principal at Frisco High School. Kate Smith completed, and so we want to have comma before and after, completed a professional development and appraisal system summative annual appraisal on Mr. Jackson. This seems to be a term of art. You can see all the capital letters. That must be the name for the appraisal document that is prepared in FISD. In this appraisal, Mr. Jackson was either proficient or exceeded his compliance in all areas. It wouldn't be at all unusual to actually attach this as an exhibit. See enclosed Exhibit A, for example. Number 7, you can see again the paragraphs are short, everything is in active voice. The racial discrimination and retaliation stems from an ongoing racially hostile environment caused initially by Coach Sam Ryder. This is not passive voice. But it has some characteristics of passive voice. So we could rewrite this and say, Coach Sam Ryder initially caused an ongoing racially hostile environment. This racially hostile environment was the beginning of the racial discrimination and retaliation that Mr. Jackson experienced. That might be one way of phrasing this. So this isn't the best, but it's still a short sentence. It's clear, so it's not bad. Because Sam Ryder and the superintendent were close friends, the retaliation began after Mr. Jackson complained of the discrimination to Mr. Smith. Okay, so Mr. Jackson complained to Mr. Smith about Mr. Ryder. We haven't heard anything about the superintendent at this time. This would be Mr. Reedy. It would have been nice to give us the name, and we saw the name earlier because he was who was the agent for service of process. But this could have been better handled, I think, in terms of the ordering of events. In fact, I think I might have started with this because this chronologically happened first, and then so I think this happened first, and then this happened. Okay, so I think this is a little bit less elegant because now we're going to jump back. Oops, wait a second. Here we go. Now we're going to, so we're talking about this event that happened earlier. Now we're talking about the appraisal. Now we're going to go on to the appraisal. So this paragraph 7 was not well positioned in my opinion. Let's continue on. On August 18, 2011, Mr. Jackson spoke with Mr. Smith, complaining of difficulties working with Coach Ryder, and advised Mr. Smith that he wanted to file a formal complaint with Human Resources. That's okay. Again, this appears to be part of this earlier appraisal meeting that he had with Mr. Smith. So this doesn't seem to flow. This seems to interrupt the flow of the story. I could imagine someone breaking this up, the first sentence in paragraph 7 into 2 sentences, but it's not bad the way it's written. Mr. Jackson informed Mr. Smith that he believed the difficulties were race-related. During this meeting, Mr. Smith instructed Mr. Jackson not to contact Human Resources, but instead Mr. Smith said that he would handle the issues. Okay, that sounds reasonably written. So now we're going to move ahead. So actually, this is, oh, I'm sorry, I was wrong. I was seeing this the same meeting, April and then August. Still, this should have gone before, unless, well, no, I guess that this is a separate meeting. So maybe this is okay. So maybe he had this performance appraisal. Then after this is when Coach Ryder started doing things that Mr. Jackson didn't like, and then that led to the subsequent meeting. So perhaps I was assuming something about the timeline. I think it could be a little bit crisper, but maybe my concern about the timeline might be a little bit off. Okay, so now we're going to move on. We're now a few days after this meeting, a little bit less than a month. On September 8, 2011, Mr. Smith conducted a walkthrough on Mr. Jackson's class. During this walkthrough, Mr. Smith noted no deficiencies. Now, walkthrough is capitalized, but it's not a term that's been defined, and it's not a term that ordinarily has a meaning to someone probably outside of the education industry. Just common sense kind of suggests that Mr. Smith, what a walkthrough might be is a brief classroom visit. That's my guess. But I think it would have been a good idea to define what a walkthrough is and how a walkthrough is conducted and what the report that is generated through this indicates. and whether this is a common thing or something that was unusual to have happened. We're going ahead a little bit more than a month. On October 19th, 2011, after Mr. Jackson informed Mr. Smith of his claims of racial discrimination. Okay, we're saying after. It's obviously after because the discussion happened August 18. But it's fine to remind, hey, just if you got lost in the timeline, it's already been announced. Mr. Smith completed a professional development and appraisal system summative observation summary appraisal on Mr. Jackson. Okay, so this is the same document we saw up here, right? And this was in April, and now we're to October, and this is unlike the April 2011, and you can see this is correct. There should be no comma between when the date is actually left out, and there needs to be no comma after here. Unlike the April 2011 appraisal, Mr. Jackson suddenly performed below expectations in a majority of the areas. Now, one thing that jumps out at me, may jump out at you, is that of course it's Mr. Jackson's position, and it's certainly implied, and it's fine. What Mr. Jackson's attorney did here is fine, but a sloppy reader might actually interpret it to mean, well, gosh, they're saying Mr. Jackson suddenly wasn't performing as well. What they really mean is Mr. Smith is claiming Mr. Jackson isn't performing as well. Mr. Jackson's performance hasn't changed. Mr. Smith's perception of the performance has changed. So I'd probably make this a little tighter and say, unlike the April 2011 appraisal, Mr. Smith stated that Mr. Jackson suddenly performed below expectations in a majority of the areas. So we see a few days later, on October 25th, 2011, Mr. Jackson requested a second evaluation. Probably would be a good idea to specify who he requested it to. In the context, it's probably pretty obvious that it was Mr. Smith. A few days later, on November 7th, 2011, in response to the October 19th, 2011 observation, so this observation must be this thing. Again, I think it would have been better to actually define what that is. Mr. Smith was placed. We have passive voice here. We knew it was coming. It's inevitable. Again, it's our first, I think, our first incidence of true passive voice in this statement. We're already on paragraph 12, so this isn't bad. But there's really no need to put passive voice here. Presumably, Mr. Smith is the person who put him on, Mr. Jackson, on this intervention plan. So instead, we should say, Mr. Smith placed Mr. Jackson on an intervention plan for student in need of assistance. The TINA was set to expire on this date. Okay, was set to expire as another passive voice. So we could say Mr. Smith set the TINA to expire on February 17th, 2012. On November 10th, 2011, a second evaluation was performed, another passive voice, by Kenny Duran of Wakeland High School. After the second, now we have what this is. Let's see, I think it's referring to this, but again, it hasn't been defined. We should have had this defined with the abbreviation. After the second PDAS evaluation, Mr. Jackson was proficient in all areas except one. So Kenny Durand thought Mr. Jackson was doing okay. One day later, on November 11th, 2011, another walkthrough. Again, we haven't had this term defined. Not sure if it's the same thing as this evaluation or not. Was conducted, we have passive voice, on Mr. Jackson's world history class, this time by Erica Castilla. So better to say on November 11, 2011, Erica Castilla conducted another walkthrough on Mr. Jackson's world history class. During this walkthrough, Ms. Castilla noted no deficiencies. we have passive voice again. We don't want to use that passive voice. So we were doing so well on passive voice, and suddenly starting paragraph 12, it's like we can't get away from it. On November 17, 2011, Sylvia Palacios, principal of Frisco High School, performed a walkthrough of Mr. Jackson's world history class. On the walkthrough form, Ms. Palacios noted that a rigorous, relevant, and aligned curricular learning targets of the lesson plan existed. She also noted that the learning targets were aligned to Frisco ISD curricula. Were aligned is passive voice. Better to say, she also noted that Mr. Jackson had aligned the learning targets to Frisco ISD curricula. By the way, this is the plural of curriculum because it's a Latin term. The UM ending becomes an A when it's made plural. So a little bit of time passes. We're now in 2012. On January 24th, 2012. Let me pause here and say, we've seen a pattern here. Almost all of these entries start with on and then a particular date. That's getting a little bit repetitive. I would probably mix things up. It's a perfectly valid structure, but to have, 1, 2, 3, 4, 5, 6, 7, 8, 9 paragraphs in a row with that structure gets to be kind of sing-songy, probably not the most effective. On January 24th, 2012, John Betcher performed a walkthrough of Mr. Jackson's world history class. Mr. Betcher found no deficiencies during the walkthrough. Now, I'm wondering here, I'm assuming Mr. Jackson probably teaches a lot of history classes. Maybe he just has one section of world history, though. I don't know. I think it might have been helpful to talk a little bit about that particular aspect. Is this all the same particular period of world history, or was he just teaching one section? And if they were kept on going to the same class, why was that? Why didn't they attend another class time as well? Maybe there was a student complaint, or maybe there was poor grades in the class or something along those lines, or maybe they were actually attending several different sections. I think that would be a helpful clarification. According to Ms. Palacios, on January 31st, 2012, Mr. Jackson approached Ms. Palacios to complain of the racial discrimination and retaliation. However, Ms. Palacios never investigated these discrimination and retaliation claims. It's not a best practice to start a sentence with however. What would be preferable would be to say Ms. Palacios, however, never investigated these discrimination or retaliation claims. When you start a sentence with however, that there's a grammar rule. It's kind of a picky little rule that some people disagree with, but the problem that you have when you violate these picky rules is that you may be making a good judgment that this is a picky, silly rule that we ought not pay attention to, but your reader may be a strong believer in that silly rule. And so when you break it, your reader might be thinking, oh my gosh, I can't stand it when people start sentences with however. And so you don't want to do that because you just don't know your audience. Number 18, during the January 31st, 2012 meeting, and of course here we're missing the comma. This is a really common comma to miss. You always need to have some punctuation when you have the month, date, comma, year. Even though this is acting as an adjective in front of our noun meaning, we still have to have the comma there. Now, I will grant you it's a weird comma, and many people, when they see it, they will think, well, that's wrong. And when you ought to think that through with your audience. It may be that remember the audience, your reader might think it's wrong, and you don't want the reader, even though you're right, and you know you're right, you don't want the reader to be seen by their thinking in his ignorance that you're wrong. And so it's probably better to say during the meeting on January 31st, 2012. That was between Ms. Palacios and Mr. Jackson. And again, this whole thing is going to have to be reworked. This is a very long, a double prepositional, two prepositional clauses, not perhaps the best way of phrasing it. Ms. Palacios told Mr. Jackson that he was not a good fit for the school district and suggested that he resign. In exchange for the resignation, Ms. Palacios offered to give Mr. Jackson a good letter of recommendation. On February, so we did break out that pattern that we had seen, but now we've returned to that pattern. On February 17th, 2012, Mr. Jackson was informed, we have passive voice again, that the school intended to recommend non-renewal of Mr. Jackson's contract for the 2012-2013 school year. Well, who informed him of this? That was pretty important information. So let's say it was Ms. Palacios. On February 17, 2012, Ms. Palacios informed Mr. Jackson that the school intended to recommend non-renewal of Mr. Jackson's contract for the 2012-2013 school year. Recommend non-renewal sounds like bureaucrat ease. I think it might be better to say the school intended not to continue Mr. Jackson's employment for the next school year. So I think that might be a better way of saying that. Additionally, on this date, an updated TINA was completed. Additionally, on this date, Ms. Palacios completed an updated TINA. Mr. Smith and Ms. Palacios updated the TINA, claiming that Mr. Jackson did not successfully complete the TINA the first round. I'm not sure about the first round. I'm not sure what they're getting at. I guess they're referring to the first TINA as the first round. Let's see. That TINA was set to expire February 17th. So I would instead phrase this when Mr. Smith and Ms. Palacios updated the TINA, claiming that Mr. Smith did not successfully complete the TINA that expired on February 17th, 2012, period. On February 28, 2012, again, we're back to this pattern of having the on a particular date. 11 days after, it's a good practice for very small numbers like this to actually write it out as opposed to using digits. 11 days after Mr. Jackson was informed, so again, passive voice, Ms. Palacios informed Mr. Jackson this contract would not be renewed. This is a sentence fragment. I'm very surprised by this. This is a very poor thing. This is a well-written complaint. I'm disappointed to see this. I'm not sure. I think that the following incident must have happened on this date, but this is, I guess you could say, I'd probably, oops, here we go, I'd probably remove this, replace this period with a comma. Let's see how that goes. On February 28th, 2012, 11 days after Mr. Jackson was informed his contract would not be renewed, comma, Mr. Jackson's name was left off the school program, period. This oversight occurred despite the fact that Mr. Jackson coached at a basketball game between Lincoln High School and Frisco High School. This is a little bit unclear to me exactly what happened because of the grammar problems. This needs to be worked on. And because it's not clear what happened, obviously it's not very effective. We also have the problem with the passive voice. This one may be an example where we're just stuck with the passive voice because at this point Mr. Jackson may not know who left his name off the program. It'd probably still be better if they just said someone at Frisco High School left Mr. Jackson's name off the program, even if we don't specify who. On March 1, 2012, Carrie Antwine performed a walkthrough of Mr. Jackson's world history class. During this walkthrough, all learning targets were stated, aligned, and evident to the students. Okay, we don't have parallel structure here because this is passive voice. This is passive voice, but this is an adjective here as opposed to a past participle. We could say during this walkthrough, Mr. Jackson stated and aligned all of his learning targets, period. In addition, those learning targets were evident to the students, period. So we have a problem with too much passive voice and lack of parallelism. On March 21st, 2012, Mr. Smith conducted another walkthrough of Mr. Jackson's world history class. Mr. Smith noted that the learning targets of the lesson were rigorous, relevant, and aligned. I think we're missing the word with here. Aligned with curricula targets. This, of course, makes this passive voice. These are adjectives, so we lack parallelism, and we also have this passive voice here. Mr. Smith knows that the lesson plan of the class was a broad topic. However, no further derogatory comments were noted. Again, we have passive voice. This is the beginning of a clause, but it's okay in this place. I'm not too worried about the however being in that location. On March 22nd, 2012, Ms. Palacios informed Mr. Jackson that the Board of Trustees would vote to non-renew, again, better to say to not renew, Mr. Jackson's contract for the 2012-2013 school year at the April 9, 2012 meeting. And again, we need to have a comma here or say at the meeting on April 9, 2012, period. Now you may say, well, I've been taught not to split infinitives. And to say to not renew is to split the infinitive. We have the word to and the infinitive form of the word, and we're now having this word in between. Well, you're right that many people object to splitting infinitives. It's not a hard and fast rule that you can never split an infinitive, but it's a best practice not to. That's true. But changing it from not to non does not solve the problem. So you could say instead, on March 22nd, 2012, Ms. Palacios informed Mr. Jackson the Board of Trustees would vote to decline to renew Mr. Jackson's contract. Again, we're back to this pattern of on a particular date. On March 28, 2012, Richard Oldham conducted a walkthrough of Mr. Jackson's world history class. During this walkthrough, all learning targets were stated, aligned, and evident to the students, and no deficiencies were noted. Again, we have a problem with parallelism. This is an adjective. The others are past participles, and we have passive, passive, and passive. On April 17, 2012, Ms. Castilla conducted a walkthrough of Mr. Jackson's world history class. During this walkthrough, all learning targets were stated, aligned, and evidenced to the students, and no deficiencies were noted. This is basically a repeat of what we saw before. We had the same problems with it. On April 23rd, 2012, Mr. Jackson formally complained to Dan Moskowski, Board President of the Frisco ISD Board of Trustees, Mr. Bass, Dr. Bass, Assistant Superintendent for Human Resources, and Dr. Rick Reedy, Superintendent of Schools. A couple of things to note here. This here is a parenthetical relating to Dan. This one is a parenthetical relating to Dr. Bass, and this is a parenthetical relating to Dr. Reedy. It's better in this situations to change this from a comma to a semicolon, and then to change this to a semicolon. They didn't even have a comma there. That helps you see, oh, this is just one unit, and this is one unit, and this is one unit. We're also missing the serial comma here anyway, or sometimes called the Oxford comma. Not required, but is a best practice. We also have a couple names here. We have Dan Moskowski, but we're missing Miss Dr. Bass's first name. I would think that could be something that could be Googled and found. And now we have Rick Reedy's first name, but we have the doctor in front of it. It would seem to me if Mr. Dan is not a doctor, we ought to put Mr. in front of it so we're consistent with that. In his complaint, Mr. Jackson vocalized his unfair treatment because of his race, as well as the school's retaliation. I don't think I don't think vocalized is the right word here, because I'm guessing that this complaint was written, and obviously a written claim is not going to be vocal. It's not going to be spoken. It's possible that he actually did meet with those 3 individuals, and then that terminology would be okay. So I could be misstating the facts here. On May 4, 2012, Mr. Jackson met with Dr. Bass and Mr. Longfellow. We don't know who Mr. Longfellow is. It would be nice to get an explanation. To fully discuss, we have a split infinitive here, his claims of racial discrimination retaliation. This his could be ambiguous, but I don't really think it is. We've heard so much about Mr. Jackson's claims, and there's no reason to think Dr. Bass or Mr. Longfellow has gone to Mr. Jackson to talk about their concerns about their own victimhood of racial discrimination. So technically this is ambiguous, but I don't really think it is. Mr. Jackson had previously submitted names and specific instances of discrimination retaliation. I'm guessing that this is up here, but it would be better to make that clearer, where this previous incident is. In response to this meeting on May 7, 2012, Dr. Bass wrote a letter to Mr. Jackson. In this letter, Dr. Bass summarily denied Mr. Jackson's claims of discrimination and retaliation, claiming that Mr. Jackson chose not to provide any information and/or evidence in support of your allegations. However, we can see here we're starting that sentence with however, so we shouldn't do that. Dr. Bass admitted that names were provided to her, but she failed to contact any of those people. Well, that's a really good fact if that ends up being true. Further, Dr. Bass conducted no investigation of the allegations of racial discrimination or retaliation, even though that is her job. Let's see, what do we know about her job? Assistant Superintendent for Human Resources. I guess that makes sense that that would be her job. On April 24th, 2012, Mr. Smith conducted his professional development and appraisal system summative annual appraisal on Mr. Jackson. Unlike the April 2011 appraisal, Mr. Jackson was now rated far below expectations in several of the areas addressed. Was now rated as passive voice. We ought to say Mr. Smith rated Mr. Jackson now below expectations in several of the areas addressed. Yet, on May 3, 2012, Mr. Betcher conducted a walkthrough of Mr. Jackson's world history class. During this walkthrough, all learning targets were, again, this is that same phrase we've seen again and again, were stated, passive voice, were aligned, passive voice, evident, not, parallel, and no efficiencies were noted, passive voice. On May 7, 2012, Frisco ISD sent notification of the scheduling of the non-renewal hearing for the next meeting, for the next morning. May 8, 2012, there should be a comma here. At 11 a.m. Mr. Jackson was given less than 24 hours notice of this meeting. Additionally, FISD arbitrarily allocated only 45 minutes per side to conduct this hearing. This is in bold and is also italicized. For 1 or 2 really important sections, that could be okay. You wouldn't want to have too much of that in the document, though. Again, that's a little bit more informal than you ideally want to have it to be. I think that this fact might be worthy of the highlighting. I don't think that this fact really is. Furthermore, though previously requested in writing in this letter and accompanying documents, this doesn't have a clear antecedent. This was the first time Frisco ISD provided the witness list and exhibits for this hearing. And I'm not sure what this letter is referring to. So there's some sources of concern here in terms of the structure of that. And you, especially at the end of your facts, you want them to be crisp and clear and be very clear about what you're talking about. So we're going to stop here and resume talking about the complaint in the next lecture. Thank you for your attention.